thanks again. Thanks for welcoming me here today. I'm happy to be back in a way. I mean, as I was checking now that it's already 6 years that I was here as a visiting professor already. I cannot believe. So I'm happy to be back and bring some new piece of scholarship, which I've been co-authoring with Stéphanie Hennette Vauchez, and it's a book about France, actually. All right, so that's the title. That's the cover of the book, which came out just a month ago in France and in French. Des juges bien trop sages qui protègent encore nos libertés. There's actually also a question mark, and it's a book about, that starts with the continuous, the emerging, worry that there is about France and a possible illiberal turn of policies regarding rights and liberties and freedoms. The fact is, an increasing number of international organizations and NGOs have been red flagging France for a shrinking of its public space. Recently, la Fédération Internationale des Droits de l'Homme, which is the umbrella organization for National League of Human Rights, Ligue des Droits de l'Homme, that you see here on the right, and that's its last report, France dropping out of democracy, which is pinpointing particularly a crisis, particular difficulty with freedom of association. There was a 2021 act on comforting the principles of the Republic, which have been extremely tough on freedom of association. Freedom of demonstration also has been a problem in the context of social movements, but also, as we are sadly commemorating this week the 10th anniversary of the Bataclan killings, 2015, the wave, the state of emergency that started that year and was actually reinitiated in the context of the COVID, which has tilted the government in favor of strongly in the favor of the executive branch. In that context, the question that is emerging is what about the role, the performance in a way of courts in defending rights and democracy vis-a-vis these changes in the way the executive treats this issue. And the fact that we've started with is, of course, a form of worry here again, with a position of restraint of French courts in reviewing acts of governments, in reviewing pieces of legislation, only rarely striking them down. And two elements could be just a proof of that. One is the report of the Conseil d'État, so the Supreme Administrative Court, making a sort of bilan of 10 years or almost of states of emergency, and arguing that certain conditions in this context require a new balance between fundamental rights and issues of security, in a context in which one might say actually that the role of courts, particularly the Conseil d'État, would not necessarily to change the balance when precisely we are in a context of emergency, but actually reinforcing the protection of fundamental rights. But beside this overview of the Conseil d'État own work during the state of emergency, one can also take the decision to 2023 of the Conseil Constitutionnel, the Constitutional Court, in the pension case. Pension is a strong social political issue in France, and it actually still is. And in a context in which there were millions of people in the streets around this, and a law had been just passed without vote from the parliament, connected to specific executive powers that there is in the Fifth Republic Constitution. The Constitutional Court actually somehow dodged any substantive discussion on rights and social rights here, and think there were many issues in terms of sex equality, rights of worker, right to pension, right to social protection, and also actually dodge any discussion on the very unusual recourse by the government to a specific constitutional procedure to have this law adopted. So the question is, are fundamental rights judicially protected in France? And to put it differently, what is the performance of courts in that matter? And we've somehow decided to move specifically in one palace of the Republic, although it's called the Royal Palace, where two of the three main courts actually are seated, have their seat. The Conseil d'État and the Conseil constitutionnel, knowing in the sense that the Cour de Cassation, the third Supreme Court, we left it aside. Why have we left it aside? For a variety of reasons. But one reason is that when it comes to reviewing public policy, when it comes to reviewing government, it's really around the Conseil d'État, so the Court of Administrative Rulings, administrative and decrees, and the Conseil constitutionnel, which really are the ones in the forefront. The second reason is that both of these courts have strikingly put forward in terms of institutional identity their performance in defending rights and freedom. You might know that the Conseil d'État was created by Napoleon and has a Conseil de l'État, literally, and is still a Conseil de l'État, literally, in the sense that it actually is giving advices to the government before governments actually adopts or propose laws to the parliament or adopts decrees that, so it works ahead and after the legal process in a way. So it has been an advisor of the government, but it has proved ever since the Third Republic, late 19th century, that it was a protector of rights and freedom, and particularly political freedoms. And it puts a lot of emphasis in all this, in a way, its report on this. And the Conseil constitutionnel also has put a lot of emphasis in its history, shorter history, because it's an institution of the Fifth Republic, to point at its emancipation in a way vis-a-vis the executive power. Initially, the Conseil constitutionnel was really thought as defensor of the executive power against a potential return of parliamentary or parlementarism, as we would say, so excesses of parliament power in a way, but it progressively indeed reinvented itself in the 70s onwards as a protector of fundamental rights. So for that reason, we decided to put the emphasis particularly on both these institutions. So here we are working on these two institutions, two Supreme Courts. Stephanie and I, it's not, I would say, a specific inquiry that we've engaged, because both of us have been working all along in a variety of angles, encountering, it's difficult to work on French public law or in French law without continuously encountering the Conseil constitutionnel and the Conseil d'État. And even as a political scientist working on law, you understand continuously, with the Conseil d'État, which is really, as we will see, a core institution at the core French power. So, but how can we then try to analyze this situation in France and make sense of what's happening? So there is, of course, a lot of analytical tools that have been proposed over the years to capture a little bit this sense of a sort of illiberal turn in a variety of countries. We know that there is such a thing as an autocratic legal playbook that has emerged around countries like Poland, Hungary, maybe Brazil in the previous time, or the US. And this, of course, is about a story about global constitutionalism. In a way, of course, these categories were essentially initially built for autocratic countries, and that makes it difficult also to just apply them from scratch to a country, more traditional democracies like France, for a variety of reasons. I think one reason is that this macro concept are not very helpful when we get to the ground and look at case law, whether things are liberal or illiberal. They are very helpful in showing the circulation of ideas transnationally, but they're not very helpful at going down and measuring, in a way, the performance of courts. And they're not very good equally at accounting for the long-lasting battle between liberal and illiberal tendencies in all democracies. You know, France has been continuously taken into this sort of tension. It's not as if before this moment France was a purely liberal democracy, and what comes out actually from our inquiry is that the period in which France might have been somehow taken into the global liberal constitutionalist period was to a certain extent a parenthesis in its history, that is in the 80s and 90s, when both these courts actually indeed embraced the discourse of human rights, and maybe, but never completely, the discourse of global constitutionalism. In a way, the Conseil constitutionnel, the Conseil d'État have always been very much spectators to this discourse of global constitutionalism and never really adjusted or actually thought of their identity in this term. So in a way, all these categories, to me, are both interesting for the circulation of ideas transnationally, but then when it comes to analyze a long-lasting history of this balance between liberal and illiberal tendencies in all our democracies, I think somehow it fails to be completely useful. So the claim that we're making in the book is, sorry, I should check it. I didn't put my clock, but I will check. So the claim that we're making in this book is a claim about, in a way, indifference. Indifference seems as a very strong term. We're not saying that both courts are literally indifferent, but we say to human rights and freedoms, but we say that these courts have an increasing difficulty to make the difference between human rights claims and other sorts of interests or general interests that appear. There is very little special status for fundamental rights in the case law of the Constitutional Court and the Conseil d'État. It could have, if I may remember that the first alinéa of the preamble of the French Constitution says the French people solemnly proclaim its attachment to the rights of man and principle of national sovereignty as defined by the Declaration of 1789. So it's really at the very forefront of our Constitution. But what we see studying the case law of both courts is a continuous balancing of human rights with emerging and continuously re-emerging new motives of general interest in the sense that both courts make up in their decision. So general interest may be the protection of the economy of the agriculture, the protection of public health. It can be the protection of public order. It can be the protection of energy sovereignty of the country. So it's a continuous balancing in which human rights appear always in a sort of unfair battle, and in which, of course, the only who's deciding in last instance of what is general interest is, of course, both of the courts. And there's also particular representation of fundamental rights in that battle, in which the general interest is really the interest of the state. And fundamental rights appear as individual rights, as somehow egoistic rights, or at least rights that actually are irritant to the capacity of the state and of government to proceed with their own public policy. So they can be sometimes useful, they can be sometimes taken into account, but they have to be somehow the exception, and they have to be somehow mitigated with the first need, which is the need to govern, the need to push forward the public policy of the government. So why is it that general interest claims feature so prominently in the discourse? Here you have a rapport public, or in the case law of the Conseil d'État and the Conseil constitutionnel. Well, one essential reason, and okay, you won't read the names and see the picture, but very precisely from here. But the idea is that one thing that has to be understood when talking about both these Supreme Courts is that they are historically very much inhabited by a spirit of a governmental habitus. I don't have the time to go into details, but clearly both institutions are instrumental to the very definition of the Fifth Republic. History shows, particularly an excellent historian, Nicolas Rousselier, in its book La Force de Gouverner, how much both institutions were somehow entangled with the definition of the Fifth Republic as de Gaulle wanted it, and its legal advisors, which were all from the Conseil d'État, by the way, Michel Debré first, saying that basically the Fifth Republic is about giving the capacity for government to govern. It's about restoring the power of the state vis-a-vis, corporatist tendencies, and of course vis-a-vis the parliament. So, for a variety of reasons, the Conseil d'État had a long-standing case law which was trying to protect government and to protect the legal capacity of government. And for that reason, was particularly central to defining the Fifth Republic. And then there's something beyond the history of the Fifth Republic. There's something about the sociology of this grand corps, as we call them. The Conseil d'État is a grand corps, meaning it's an elite of the state, meaning that these judges move in and out of that Supreme Court continuously, and they are positioned in a variety of public enterprise, public utility firms, top government positions. They're heads of a cabinet of ministers. They're top legal advisors in all ministries. They're heads of regulatory agencies. They continuously draft the law at all points of the legal process, in a way. So in that sense, they feel co-responsible for the law of the state. And not only are they just as an example, I put it here in the slide, 162 member currently of the 300 members of the Conseil d'État, of these 152, 62 have been members of ministerial cabinets, showing how embedded they are, entangled they are with government. The same could be said with Constitutional Court, differently because the Constitutional Court is more of an end of a career type of position, but previously, they've in a majority of them been in a political or bureaucratic position in the state. So in a way, sociologically, institutionally, and in the end, cognitively, they are close to the way governmental actors reason. They are particularly sensitive to their grande affaires or big issues, and in that sense also tend to incorporate and think of their role not so much as being exterior to government, as being a counterpower to government, as being a third power in a way, but as being an accompagnateur, accompanying the state in the government in its policy, maybe moderating sometimes, but also legitimating at the same time its policy. So another argument for that particular governmental habitus is the extent to which both courts, the Palais Royal, we call them in short, have been somehow key to all the big bangs that the French state has encountered. As most states, but probably even more than other states, given its particular history, the French state has been profoundly upset in a way, or ever since the 1980s. Three particular upsetting that we are studying in the book: European integration and the move to the single market, competitive and free market economy. The challenge of terrorism and security, of course, in particular after 9/11 and even more after the Bataclan, and the globalization, and in other words, sovereignty. What sort of sovereignty is there still within the French state? And strikingly, each one of these challenges correspond to a huge program of legislation, huge program of legislation, it's hard to understand, to figure out the extent to which, for example, the moving into the single market has created and hundreds of bills over ever since the 80s, and we put that, and all of that is a huge legal energy into readjusting the position of the French state vis-a-vis the market, vis-a-vis market actors. And in that, members of the Conseil d'État and members of the Conseil constitutionnel have not been only judges at the end of the line. They've been drafters, they've been theorizers, they have been counselors to these moves, and in a way they've been taken into the apparatif of, in a way, driving the state in that context. The same could be said for security. There's dozens of legislation on that, and sovereignty as well. The issue here is that is that both courts have been, of course, in a way, questioned by the European and international internationalization in a way, and of course, and their position has been very interesting in that matter. Maybe I can say a few words here in particular, because well, up until the 80s, the Conseil d'État, was not reviewing, administrative decrees vis-a-vis European law. So it's only with the Niccolo decision in 1981 and 1989, and one could say that it was an opening to European law, but to a large extent, and also to international law, because it was not only on European law. Niccolo was about all sorts of sources of international European law, but with a more fine-grained look, shows that actually it's less of an opening than of the Conseil d'État positioning himself as the gatekeeper, filtering what sort of international law, European law, is deemed to be passing, and to have binding effect in the French context, which is extremely important because, in a way, the French Constitution, beside its first alinea that I read, has not that much human rights disposition. So it's the fact the international and European law is very important in bringing into French law a number of human rights standards. And the fact is the Conseil d'État has been very much conservative in, what is the International Covenant of Civil and Political Rights worth for. And in a way, it points at the fact that it has no binding effect in France, and the findings of the Human Rights Committee has no binding effect on France. So in a way, it positions itself precisely at the border, precisely to somehow maintain the legal sovereignty, or to somehow negotiate the new legal sovereignty of the French state. So, and in that, it also can be shown in how French Conseil d'État members are sent to European courts. And they're not just sent to the European courts because we need a French judge. They also send admission. It's members of the Conseil d'État think very much of themselves as having a mission to defend the influence of French law. But not only the influence of French law, also for many of them to defend also ideas of to avoid excessive, I would say, supranational law or supranationalization of European law vis-a-vis France. And in that also, the Conseil d'État plays a sort of role. Jean-Claude Bonichot, who's been for 15 years a member of the Conseil d'État, member of the Court of Justice of the European Union, and the current president of the European Court of Human Rights, who's also from the Conseil d'État. Yeah. So I'll be very brief. I see the time is. So why should we care about all this? Well, I think one element is, that's the last part of the book, is that we test a little bit how the Conseil d'État is dealing with new challenges of rights, emerging issues of ecological rights, issues of equality in the sense that to the extent to which non-discrimination paradigm is making its way in France, a country in which the notion of equality, particularly in administrative law, is extremely important. So, and civil society, by which we mean political freedoms, and particularly the defense, for example, of freedom of association that I mentioned earlier, and that bill I mentioned earlier. So to what extent this governmental habitus makes the Conseil d'État, the Conseil constitutionnel, somehow blind or half blind, to put it more in a more balanced way, half blind to emerging claims from society or new generations of rights, which we think is essential to the vitality of democracy. It's not just an issue of extending continuously rights, but it's also an issue of protecting democracy and its capacity to renew itself. But that's something we can discuss later. So I can give examples on how recently, for example, in the case of environment, the Cour constitutionnelle was given to review the Loi Duplon, which was a controversial law upholding a ban on pesticides, which had been convincingly shown as being a problem to health. And indeed, the Conseil constitutionnel recognized that there was a problem in terms of health and in terms of the capacity to live in a secure environment. But it said that, yes, there is this, but there is indeed also the equally important general interest motive of protecting certain agricultural sectors and to face serious dangers threatening their crops, and in order to preserve their production capacity vis-a-vis competitive distortion at the global level. And it's showed in a way that the possibility of derogating to rights protection when general interest, again, issues are put forward. So I said it, I stop it here. This is a conclusion where I talk more about reform, possible rethinking about the position of both these courts, and somehow to hope how that we could improve this performance of courts in terms of human rights in France, but that I suppose we can also tackle in the discussion. So thank you for your attention.